without further ado, Matthew, I will let you take it from here.
Great. Thank you so much. And thank you for setting up this webinar. I really appreciate it. I really feel education is key to really things going smoothly when you might not otherwise expect them to be going not so smoothly. So I appreciate this opportunity. And in today's webinar, I have some slides that I'll be putting on board in a few minutes. And first, my name is Matthew Matrisciano. My law firm is MGM Law Firm, or Matthew George Matrisciano. And I specialize in estate planning. And as part of that, I also specialize in special needs planning, long-term care planning, and how that relates to estate tax planning, as well as estate administration, like probate, trust administration after death. And hopefully my screen is shared now. I'm seeing nods, so that's excellent. So today is some basics and a high-level view of some advanced topics. Really, there's a lot that I could cover, and rather than go too far in depth in any one area, I'm trying to give a broad overview because there's really a lot of distinctions. First, as a lawyer, I always have disclaimers. What I'm giving you today is not legal advice. Talk to your own expert, and I can't possibly get through everything today that you might have questions about, but there will be Q&A at the end. And then all the other legal disclaimers that you would normally see, just pretend like I said them. So topics today, I covered probate pretty extensively last year, and that recording is available through Western Title. So I'm going to touch on it today because it all connects with the other issues, but I won't go in depth. I'll be talking about wills, beneficiary designations, revocable trusts, estate taxes, irrevocable trusts, and then different pieces of incapacity with the powers of attorney, conservatorships, healthcare directives, and then certain multi-state issues that you should be aware of. So to start out with, well, the broad overview with probate is that when you die, everything goes into probate. And the exceptions then are items that are jointly owned with rights of survivorship. That does not go into probate, it goes to the survivor. And when the survivor dies, it would go to probate, likely, unless another exception applies. Beneficiary designations, whether it's transfer on death, TOD, or pay on death, POD. Any assets that are in a trust also avoid probate. Those are the biggest exceptions. Probate is a court process in which the judge oversees the person in charge. In Oregon, it's called the personal representative. It's the same as the executor, though. And the court oversees them and make sure that they're doing what they're supposed to do, pay taxes, debts, and ultimately distribute the assets where they're supposed to go. There's a lot of hoops to jump through, and it's not all bad. There's a lot of bad rap about it, but because it's public record, which means what you had when you died, the address and name of every individual who's receiving something and what they received is all public record. But for that reason alone, the vast majority of people I recommend against probate for. And Deschutes County, because the Ben Bolton has a monopoly on what the court has approved as a public notice. It's a little bit more expensive than other counties. And the initial cost is $1,500 just to pay the newspaper or pay the court. And the total cost can easily approach $10,000 without complications like contesting. So let's try and avoid that. In terms of wills, first, wills do not avoid probate. They tell the probate court who's going to be in charge and who gets what, and sometimes in what circumstances. So you can still, in a will, say, I want to create a revocable, excuse me, I want to create a trust if my children are still minors when I die, or I want to create a trust for a special needs person. But that trust has to be then created in probate. Wills are a good idea for people who um, don't have the desire or ability to follow through with setting up a living trust. It's a little bit more of the set it and forget it. My analogy that I like to use is if everything you owned is on your kitchen table, everything is just there. So whenever you buy something new, it pops up on the table, and a will would be a post note saying, hey, whatever is on this table, here's what I want you to do with it when I die. You can, in that will, you can pretty much do anything you want that's legal. You cannot completely disinherit a spouse, but you can disinherit other people. Um, you can buy and sell property in your name. You don't have to keep track of what you own or anything else. However, it's important to understand that if you own something with rights of survivorship or have beneficiary designations, one of the other exceptions to probate, then your will might say, I want everything to go to my kids, but you forgot that your beneficiary designation for your retirement account still lists your ex-girlfriend. Literally, I've seen that. Not good. So, revocable living trust. Uh, Sorry, I had to jump around a little bit. I am having a few technical issues that I just resolved. My apologies. So the revocable living trust, if a post-it note is the will, I would say a trust is more like a treasure chest, and its lid is open. When the trust is created, that chest is empty, and so you need to start putting things in there. Otherwise, it's empty, and the note on the chest that says, here's what I want uh, to do with my assets when I die, there's nothing that it applies to. To start with, the grantor is the person who creates the trust, and they're considered the owner for tax purposes and creditor purposes. So if you create a revocable living trust, you still can sell your house. When you sell your house, any tax associated with that sale is still yours to pay. You don't even tell the IRS you've created a revocable living trust, because at any moment you can just say, I revoke it. Everything is mine now. So you really are considered the owner. It is primarily for um, probate avoidance at the outset. Now, within a revocable living trust, you can do some planning later that will help with state taxes and in some instances, income taxes and things like that. But when you first create it, it does not affect taxes or creditors. So if a creditor can sue you, they can sue your trust to the same extent. Normally, if a couple creates, a married couple wants estate planning, they'll create one joint revocable living trust, but it depends on how they do their finances. I've definitely had people who come in and they have his bucket and her bucket, or his bucket and his bucket, or whatever it might be in the situation. So what that means is you can still create two revocable living trusts that work together, where they each have their own, so that if there's children from previous relationships and the finances have always been separate, they don't have to suddenly be joined. After one spouse dies, oftentimes part of the revocable living trust might become irrevocable. And in that case, a second trust is created. And we'll talk more about that, but there are some reasons to do that. The most common reason to do that is estate taxes. So we'll get to that section a little bit later. You could also create an irrevocable trust upon the first death in order to protect your inheritance for children from a previous marriage or something along those lines. It's very flexible in terms of planning options, and it's important for the client to understand what their goal is going in. Is it primarily to take care of each other, take care of children? Is tax avoidance a big goal? And as I said before, your trust only has control over those things that are owned by it. So when you create the trust, again, think of the treasure chest. If it's empty, then when you die and that lid is closed, it won't actually have control over anything in it. But you could, in many instances, have your trust as a beneficiary of certain accounts so that when you die, now there's something in the trust. So different things that a revocable trust can do. It can avoid probate, can be flexible, it can be used to reduce estate taxes, and that's specifically for couples. There's other planning options that an individual who's not married can do, but not through a revocable living trust. You can maintain control over beneficiaries. So I don't want my kids to get their entire inheritance when they turn 18. So my trust will now say, I want my trustee to pay for their health, education, and support. And you know what? They can get everything when they're 35, or they can get half when they're 25 and half when they're 35. Or I don't want them to get anything at all unless my trustee says so. I want my trustee to stretch this out for their whole lifetime until they get their retirement. So, that's more of like a trust fund situation. You can plan for spendthrift beneficiaries in that way, people who are just going to spend the money as soon as they get it. The statistics are that an inheritance is spent about as quickly as lottery winnings. So that's going to go fast. If you kind of kept on or heard about news about lottery winnings, I mean, it doesn't matter how much people win, within a very short period of time, it's gone or almost gone for most people. With a revocable living trust, you can plan for charitable contributions, and you get to choose a trustee, and that's obviously very important. It needs to be someone you trust. I would say pun intended, but I think it's just right there in the name. The trustee needs to be someone you could trust. And they can react to the unexpected. So a well-drafted trust would say something like, if my adult children ever become special needs children because of a head injury or because they are now approaching retirement and need Medicaid or anything else, then instead of receiving money immediately, now trust is created on their behalf, help them qualify for government benefits, and have a little extra on the side. So lots of options there. Estate taxes, they're complicated, and Oregon is different than federal. Each state treats estate taxes differently. I'm going to focus on federal and Oregon today, though. And federally, the estate tax exemption is $12.92 million. So if one person dies, anything over $12.92 million is taxed at 40%. If a one member of a married couple dies, then the surviving spouse can file a simple IRS filing and port is called, port that exemption to them. So now when they die, they have that spouse's $12.92 million plus whatever theirs is when they die. And if they die in the same year, then it will be twice that exemption amount. However, it's important to note that on January 1st, 2026, I say that will decrease, but it's expected to decrease. The legislature could always step in and change this. It's going to decrease to 5 million, indexed for inflation from, I think it's 2010. So once you add up inflation from back then, it's probably going to be about $6 million. And the tax rate's going to be increasing from 40 to 45%. So if someone dies, a few years from now, after 2026, then now if they had, $7 million, that would not have been taxed if they died this year, but it will be if they die later than January 1st, 2026. So while there's still not as many people who would need to worry about that, there's a lot more who need to worry about a $5 or $6 million exemption than a $12 million exemption. Oregon, though, is different altogether. In Oregon, there's a $1 million exemption. Anything over $1 million is taxed between 10 and 16%. And that cannot be shared with a spouse. So you have to use it or you lose it. This is where we use the bypass trust, also called the credit shelter trust. There's a few different names for it. Specifically, if I create a revocable living trust for a couple, when the first spouse dies, I can say that I want to use that deceased spouse's exemption and create an irrevocable trust from the revocable trust. And that's called the bypass trust. It uses their exemption. And that irrevocable trust, we want to make it as available in most situations, as available as possible to the surviving spouse. So in a situation where you really want to make sure the surviving spouse has access in the event of any emergencies, so it doesn't affect their livelihood and their the way they go through life, then you want to make sure the surviving spouse gets all income from that bypass trust, and that the surviving spouse has access for health, maintenance, and support. So health could be healthcare emergency, long-term care, if needed, other things, so that they have it there. Maintenance and support, the IRS has defined that over a lot of time and cases and regulation. Maintenance and support means, I would say not means, it includes things like taxes, insurance, it includes things like housing and vehicles, and it also can include a regular vacation. As long as it's not an extravagant vacation, you can't blow it all in Vegas. And so there's really a lot that is possible, but there's just enough of a restriction where it's to be considered owned by the deceased spouse, so it uses their exemption. So if the couple altogether had $3 million to their name, then when the first spouse dies, you use that bypass trust, put $1 million into it to use their $1 million exemption, and the surviving spouse is left with $2 million in the regular revocable living trust. When that surviving spouse dies, they didn't move any money around, then they died with $2 million in their name and in the name of the revocable living trust, which for tax purposes is in their name. Then $1 million of that uses their exemption, and $1 million is still taxed at 10%. So you end up with $100,000 in estate taxes to the state of Oregon. So that is a simple example. There's more tools that can be used to reduce that further. There's other things that can be done. But my goal is to really think through what is that person's actual primary goal. So is it to reduce taxes and provide the most amount of money to the kids as possible? Or is it to maybe just reduce it a bit, reduce the burden on the children, but let's make sure that the two clients who come in, my clients, are comfortable and have access to their money. And where is an in between for this? And that's the kind of thing that we work through. So that is one of these types of irrevocable trusts. So that revocable trust could be created by the revocable living trust, that bypass credit shelter. It's also called an AB trust, if you've heard that term. Minors, also, they should, an 18-year-old can legally, start to be in charge of their own money, or an emancipated 16-year-old. But if a 10-year-old inherits $1 million and it just goes not through a trust but to them directly, then it goes in a custodian account called a Uniform Transfer to Minors Act account, and they have to get it when they turn 18. Most parents wouldn't want that, and so having an irrevocable trust be created when you die, so that the children don't get their funds until, like I was saying, they're half when you're 25, half when you're 35. You can choose whatever you'd like, and it's important to talk through that with the estate planning attorney who's helping you through your trust. The other option is that sort of legacy trust fund for either adults or minor children, so that it lasts longer in their lifetime. There's also the potential for substance abuse and trust that can incentivize someone to get through treatment, maintain levels of sobriety, and there's a lot of variation that's possible. There's a lot of variation in terms of what people think works and what works for different people. So talking, if there is an issue, talking through that with your estate planner. And if your children are 4 years old and 10 years old, then maybe including a provision anyways, because we just don't know what the future holds. Irrevocable trusts have many of the same benefits. They avoid probate, they can reduce estate taxes, they can plan for uncertainty, and minor or special needs children. But if you create an irrevocable trust immediately, it's irrevocable upon its creation. And as realtors and title officers, this means the trustee, the person in charge of the trust and in charge of selling a house and the one who's going to sign on it, is not the person who created the trust. So if you see a home and it is in the irrevocable trust of Bob Jones. Probably Bob Jones is not actually the one who needs to sign on it, and you need to see either the trust document itself or a trust certification in order to determine who is that person in charge. Life insurance trusts are common, were more common, certainly, but Oregon still has a low estate tax exemption. And so life insurance trusts can remove something you're not using during your lifetime from your taxable estate. You know, if you had a $700,000 home and $1 million life insurance policy, but when you die, that life insurance policy is included in what Oregon will tax. So you can remove that from your estate using a life insurance trust, and that is irrevocable. But that often makes a lot of sense to avoid or reduce estate taxes because most people don't plan to use anything in their life insurance during their lifetime. If you want to sell the life insurance during your lifetime as a life settlement or something else, then you still have a trustee who's in charge of that and could possibly do that. The asset protection trust is another common irrevocable trust. I will say irrevocable trusts are not super common to begin with. So when I'm saying they're common, I mean in this type of trust. But an asset protection trust can remove some asset or assets from the reach of future creditors, and that could include Medicaid planning. But you cannot remove it from the reach of a current creditor. That is a big no-no, and could get you into some federal trouble, including criminal trouble. So you want to, so don't ever try and avoid a current creditor. But if you are interested in asset protection planning, then this might be, something that can work. If you are already interested in charity, then there are ways of getting an immediate tax deduction on, so I apologize, let me regather my thoughts here. If you give something to charity now, then you get a tax deduction for it. And then that item is out of your estate, your taxable estate, and so it reduces estate tax too. That's the simple idea behind the charitable remainder trust, but the idea there is you would put, let's call it $100,000 in a trust, and that trust then pays you and your spouse for a certain period of time, and the remainder of whatever's left in that trust would go to charity at your death or sometimes after 20 years. And you get a tax deduction now because you are creating an irrevocable gift to charity. It just that the value of that is not the full 100,000 you contribute, but it's some lesser amount depending on how it's set up. So for charitably inclined people, a charitable remainder trust can make sense. In general, irrevocable trusts are far more complicated in the trust relation to tax laws, creditor rights, but for the right person, it can be a huge added value. So the biggest one that I would be aware of, and probably most of the people watching right now, most of the audience is going to be in the real estate field is this asset protection trust, which could certainly contain real estate. And then there's going to be legacy trusts and other, sort of trust for children, which similarly can contain real estate. So we talked a lot about what happens when someone dies, but it's very likely that I think the number is in the mid 70s, 72 or something percent of people end up needing long-term care. And uh, I feel kind of like uh, what I heard, that 64% of statistics are made up on the spot. Did you know that? But uh, for real, there's a lot of people who end up, over 70% of people end up needing long-term care and possibly being incapacitated. So we plan for that through a living trust, which says the trustee can step in if the person is incapacitated. But that only takes care of the things that are owned by the trust already, the things that are in that treasure chest. So for everything else, whether it's a retirement account or decisions about Social Security, decisions about applying for government benefits, anything that's not currently in the trust, you need that power of attorney. It is the least expensive document we're talking about, but I would say there's a big difference between the ones I've seen online and a thorough one that's created by an attorney that specializes in estate planning. One of the biggest differences is going to be long-term care planning and estate tax planning. You basically is someone actually allowed to move your assets around in unexpected ways because it's going to benefit you in the long run. And power of attorney is very important because it appoints somebody, if you're incapacitated, to be in charge of your finances. But without it, without this power of attorney, you need to apply for a conservatorship in court, and they're generally about as costly as probate, a little bit less, but it's public record in terms of there is now an incapacitated person who can't be in charge of their own finances. And first of all, I just don't like the idea of that. It is frightening that that's public record, but the idea that this power of attorney that is a pretty simple document to put together could have prevented $6,000 and all this hassle in court. I hate that that happens, and there's a lot of people who are. I've seen people who are diagnosed with dementia and still don't seek out something simple like a power of attorney. And 5 years later, 10 years later, when now they can't do anything themselves, someone has to file a conservatorship. So, if there's someone who needs long-term care, that maybe that's why they're selling their home or anything else like that, I would invite you to try to add value to your conversation with them by asking about their estate planning and durable power of attorney and things like that. And if you don't have, if you need a conservatorship, that's because something's not in trust and there's no power of attorney, so there's going to be a probate. So it's a double whammy there. Also, if someone's incapacitated, then there's going to be a need for healthcare. And specifically, who's going to make healthcare decisions for you if you can't make them for yourself? The Oregon Healthcare Directive allows you to appoint a person to make healthcare decisions for you. And you can make certain choices about generally tube feeding and life support. And it doesn't specifically deal with dementia and how, in the event of dementia or Alzheimer's, people can be hand fed even when there's really nobody upstairs anymore. So I would invite each person who has one of these to really think about that and you know, get through that hard question of, do I want to be hand fed if I am in a state of dementia, especially if there's a diagnosis and you really need to think through what is the likely outcome here. And I've been I've seen how old healthcare directives may not be honored by the hospital, and so they really need to be revised every 7 to 10 years at least. If they get past 10 years, and you run the risk of the hospital not honoring it anymore. And I think that's just because people change their minds, and they really do. I think we are all very different people than we were 10 years ago, and I think we will all be very different people 10 years from now. So that's probably why the hospital does it that way. But the advanced directive itself is available at, I think, all hospitals for free, and I would highly recommend that that be part of what what everybody does. Just make sure they have an updated one, and realize that it doesn't deal with every situation. It doesn't, like dementia, for instance. HIPAA waiver is also something that can be important if you want somebody to be able to access your health information. I know that there's a number of different forms, and there's my chart here in Central Oregon for the hospital, and you want to make sure that any waivers are there so that you can make sure family has access to healthcare information, especially if there's an unmarried couple. There's no automatic allowance to anybody unless you're married. In some instances, there's some access for children. But the moment someone turns 18, even, you need a healthcare directive and a power of attorney so that someone can walk you through that, help you in the event that you can't. The other is disposition of remains. In other words, do you want to be cremated or buried? Who's going to be in charge of your remains? I've been surprised how often this becomes one of contention among family members, where there's a fight over, no, they want to be buried or cremated, or no, it's this cemetery, it's not that cemetery, and you just want to appoint someone to be in charge so that there's just one person, there's no argument among family members. My last few minutes here, we'll talk about some multi-state issues. And I think after that, yes, we have some Q&A. So I'm actually on schedule. I can't believe this. So in terms of multi-state issues, it's important to understand that every single state that owns real estate, which includes oil and mineral rights, has to have a probate unless it's jointly owned with survivorship, or unless there's a beneficiary designation, something, or in a trust. So if I've had some clients that own even small oil interests, and they actually have had two this year where everything was in a trust except for an oil interest, and after someone passed away, the oil company says, well, we'll give you the information you need after you file a probate. So we have one check from an oil company and it's for $200 and that covered the whole year. But does that mean that $200 is how much they got last year or the year before? Is it even worth filing a probate? If you're getting $20,000 a year, yeah, file a probate, get it in your name. But do you want to spend $5,000 on a Texas probate if you're going to get an oil interest worth $1,000 out of it? Some people say yes for speculation, but oftentimes it's just not worth it to the client. So just know that every piece of real estate and every mineral interest in any state is going to require probate unless there's some other way of dealing with it, like being in a trust. So estate taxes are due in, I'll just talk to you really briefly. California has no estate tax of its own. Washington has an estate tax exemption of 2.2 million around there, but that's indexed for inflation, so it goes up a little bit every year. Oregon's is 1 million, like I said, and that's not indexed for inflation. And you look at the total value overall, and that determines whether or not this tax is due. So if you had $5 million, but you lived in California and all you had in Oregon was a $200,000 piece of land, then it would still require an Oregon estate tax to be paid. It would just be a lot less because a very small percent of what you owned is here in Oregon. Technically, that even means if all you owned was a grand piano in storage in Oregon, you'd have to pay a state tax on that too. So that's sort of a multi-state issue where if you own some real estate in Washington and some in Oregon, then you could end up paying state tax in multiple states. Community property, like much of what we're talking about today, I could spend a whole conversation just on this. Oregon is not a community property state, it's a separate property state. But here's a little trick. Every state that borders Oregon is a community property state. So if it touches Oregon, then it's a community property state. So there's a lot of differences that community property has. And I'm not going to get into like all the divorce differences and things like that. But after someone dies, under current law, there's a step up in basis or down. There's an adjustment in basis to the value of date of death. So if an Oregon couple owns a $1 million piece of property and they bought it at $100,000, let's say it was a rental, so there's no other exemption. When the first spouse dies, their half of that gets a step up in basis. And if the surviving spouse sells it, then they would be paying half of the capital gains tax than they would have been otherwise. And that's because when you die, there is an adjustment in basis to the value of the date of your death, of what you own. But community property is different. If it's community property, then there's a step up of 100% of the value of that property. So if the surviving spouse sells that $1 million property, when the deceased spouse, if they die when it's worth $1 million, then there's no tax basis. The tax basis is $1 million, and there's no capital gains tax at all anymore because it's community property. You cannot create community property in Oregon, but you can bring it with you from another state. So if a California client buys some Oregon real estate and then moves into it later, if you talk to the CPA, talk to a professional about whether you can trace that backwards to be community property, so that if the surviving spouse is selling it, there might be little to no tax that is owed on that. So again, that's a bit more of a teaser, but it's just super important and one of those things that can make a big difference. The last multi-state issue I want to touch on is the healthcare directive. I've been told by an attorney at a local hospital that they've instructed staff that the attorney's office has to review the out-of-state healthcare directive or living will or healthcare power of attorney, is all kind of different names for a similar thing, because they want to make sure that it complies with Oregon requirements, and most do. But that also means that if you're relying on an out-of-state document, then you go into the hospital, let's say on Friday night, and the attorneys aren't in their office until Monday morning. They may not be able to call anybody to make healthcare decisions for you for several days. So just another important piece there. Um, you know what? I was going to go for one more thing, but I think we're right on time. Let's move to the Q&A and see if there's any questions.
Yes, we have some great questions actually. So I'll just kick it off. Since Oregon is not a community property state, why can someone not completely disinherit a spouse? Asking for a friend.
Oregon still has a spousal election statute, and depending on how long the marriage lasted, that any spouse, even if they were married for a month, I think they're entitled to 5% of the total. And it goes up to 33% if you've been married long enough. So it's not community property, but there's still laws in place that do similar things. It's different.
Can you name a beneficiary who is not the trustee who lives outside the United States in the trust?
You can name a beneficiary located elsewhere, yes. If you make a trustee someone who's located outside of the United States, then it certainly could easily become an international trust, which triggers multinational tax issues, and you don't regularly want to do that. So, but in terms of beneficiaries, I have never seen an issue. Maybe finding the person, but you know, if they're a resident of a different country, that country may have laws about taxing inheritance upon receipt, but that's different from an estate tax, which taxes before the beneficiaries receive it.
If you have a revocable living trust with a named trustee, do you still need to have a power of attorney made up?
I highly recommend having both a trustee and a power of attorney agent, and that they be the same person because they're doing the same job. The trustee hat allows them to act on anything that's owned by the trust. Power of attorney hat allows them to act on other financial and property related decisions that are not owned by the trust. So, that might be decisions about Social Security, retirement accounts, or maybe the life insurance is going to list the trust as a beneficiary, but while they're alive, it's not owned by the trust yet.
I think you addressed this kind of in reverse. Is the Oregon Healthcare Directive still valid if you move to another state?
The healthcare stuff is interesting, and I've not had a lot of contact with that specifically. My understanding is the answer is going to be yes, but I think it depends on the state, and I have not had it, certainly not had an interaction with every state. So when anybody moves to another state, I absolutely recommend you get new healthcare directives and possibly a new power of attorney, depending on what that power of attorney allows. So if a California power of attorney says, do some Medi-Cal planning, that's different from Oregon's Medicaid program. And so there might be some differences in the power of attorney, but the healthcare directive, yeah, you just want to make sure you have that current in whatever state you move to.
Are there any estate tax advantages to shifting properties into an LLC?
It depends on how that LLC is set up. Most are disregarded entities, which means for tax purposes, it's also the same as you. So, its income is your income. Its assets are considered to be owned by you. However, if the LLC owns, I'll say this, a business interest is not considered to be real estate. A business interest is considered to be more like personal property. So it's going to be taxed based on where you are located. So, for example, if you have a piece of real estate in California and you have an Oregon LLC, then you could be accidentally pulling that California into your Oregon estate tax, whereas normally it could be outside of that. That's a complicated area, but that is a concern that is worth asking questions about.
And in a similar vein, when you have an LLC for your real estate holdings and the LLC is in the trust, is it better to have title held in the name of the LLC or in the name of the trust, or does it make a difference?
If title to the real property is in the name of the trust, then it's the same as you owning it. There's no LLC protection. So if you have that limited liability protection that you want through the LLC, then the LLC can be owned by the trust.
Can you please give us a few examples of asset protection trusts?
So if this can go long if I get into this too deep, but briefly, okay, so Medicaid planning is important because how are you going to pay for your long-term care? Now Medicaid says you are allowed to have a house, a vehicle, and $2,000 to your name, and then you qualify for Medicaid. They also say that if you give away property, then they're going to penalize you for a certain period of time where you wouldn't qualify. But that only works if it was within the last 5 years. If it's more than 5 years ago, they don't care anymore. So in order to maintain, in order to do some planning, you could put some real estate or some money into an asset protection trust because you don't need Medicaid for the next 5 years. And after that period, in this asset protection trust, now if you need Medicaid, Medicaid does not consider you to have access to that trust. It's not counted for Medicaid purposes. You could still qualify for for Medicaid to help with your long-term care costs. But now you have this trust on the side here, and specifically though, in order to not be available to you, you cannot have access to it. You cannot have a right to withdraw from it, and things like that. So it's a detailed discussion. I spent an hour solely on that type of on that Medicaid asset protection trust, talking with clients about consequences, safeguards, and what else that trust can do and can't do. So I would say very briefly that is one option, and in a very brief setting. I know it is hard to sound, it's hard to get through, and for some people it sounds very odd. But I just, knowing that is there, ask more questions about it. Feel free to email me if you have more information or more questions, and I can certainly get into more detail.
If you move to a state different than where your trust was created, do you need to make a new trust for the new state? And additionally, do trusts need to be recorded?
Trusts do not need to be recorded, and that's part of the reason that they're a private document. So that's generally a good thing. Now, if someone sues and says, no, the trust is, they didn't know what they were doing when they signed it, they were coerced, whatever, then sure, it could become a public document at that point, but no, it doesn't need to be recorded. Which is also, you need to be careful about where it is, that it's not lost, that there's backups, etc. So I always keep a copy in my office and the originals with the client. The other question that I would say, it depends on what the trust is trying to do. A trust is valid in every state, but I've seen lots of trusts coming from California, for example. I pick on California because I'm licensed there. I see a lot more from there. And in California, there is no state-to-state tax. So even with trusts that try and do estate tax planning, the trust specifically says, I want you to create this bypass trust to avoid federal estate taxes. That means it doesn't help anymore with Oregon's estate tax. So yes, in that instance, something would need to be redone. If the trust is solely for probate avoidance and not for something more sophisticated like taxes, then you probably don't need to change it. But it needs a review regardless, because a lot of people don't know what their trust does. I know that when people leave my office, they sometimes, it's complicated. That's not what people think about every day. And so if you did your trust 20 years ago, 10 years ago, 1 year ago, there's probably a good chance you don't remember the details about what it does anymore. So it's always good to have someone review it if you're moving in from another state.
Can the Oregon Trust be the beneficiary on out-of-state oil and mineral interest accounts to avoid probate?
If they have beneficiary forms through their company and their contracts, then yes. Anything that lists the trust as a beneficiary and is going to be legal and honored, that would avoid probate.
Well, I wanted to give Ariana a chance to chat a little bit about our interaction with trust from the escrow standpoint. Ari, do you want to speak to what we need to see or what you generally see, or?
Yeah, to play off of that question about trust needing to be recorded and then being private documentation, I just want to bring to light that there's quite a few circumstances that title will request a full copy of the trust agreement. So I feel like it probably is always helpful if your client is forewarned that it is potentially we could be asking for it at some point during the transaction. If you know the successor trustee is the one who is signing because the original trustees have passed, please just anticipate the full copy of the trust agreement and any amendments being requested from the title department. We have to confirm that the correct successor is signing off on behalf of the trust. We see a lot in chains of title where people have moved their properties in and out of trust in what we refer to as an uninsured transaction. Again, if that has happened in the chain of title, we will be requesting potentially a trust certification or a full copy of the trust from whoever was signing off on behalf of the trust. I get this question quite a bit, and I know Matthew has already spoken to it. Just because there's a will, that does not mean that they have the authority to sell the property, because the will dictates that person has rights to the property. So title will require probate. I get that call quite a bit, especially right now in this climate. There seems to be a lot of that going on. Please reach out to me if you have a listing and you know it's considered inheritance property, and the original owners have passed. Please call me so that we can make sure everything is lined up, so that when you do put it on the market and you get an offer, we're not working backwards. Also, that
I would reiterate that and say, do not wait until the offer is there and closing is in a week to ask an attorney to open probate.
right. Matthew has gotten quite a few emails from me asking for that. So he is reiterating what I've already brought to him quite a few times at this point. Also working off of that, if there's more than one person on title and just one person has passed away, please make sure you check in with me again before you put it on the market to make sure that other person has survivorship rights. I've seen quite a few times where they actually don't have survivorship rights. And again, you end up in probate if it's not in a trust. One other quick mention, and then I will, I'll leave you all to it, but this has come across my desk. Owners who have purchased properties in tax foreclosures. I have one on my desk right now where the owner purchased it through a tax foreclosure. The owner had actually, the original owner had already passed away, and the county does not do the proper due diligence to confirm that the heirs have been notified for the foreclosure process if the county is taking it back over taxes, unpaid taxes. So now we have to go through the probate process for the previous owners in order to issue clean title. So keep this in mind. If you have a client who's purchased property in a tax foreclosure and is now going to put that property on the market, it is very, very beneficial to reach out to me to make sure that the proper parties were notified. Otherwise, we end up with quiet title or a probate route. And that's kind of all I have from my side.
Thank you for your time, Matthew. Thank you for your time, Ariana. Both of you are always a resource for our clients. We will be following up with an email with the recording of this, Matthew's slide deck, contact information for both Matthew and Ariana, as well as Hannah and myself. Any questions that you have, please feel free to use us as a resource. Those CE certificates you'll see by the end of the week, as well as the email that I just spoke to. So thank you for attending. Thank you again, Matthew.
Yeah, you're welcome. Thank you.
Have a great day.
Thank you.